affected because they represent GE Capital, and there's a conflict that the other firm is suing GE Capital, stuff like that.
So where's the
I
lending
probably
go?
shouldn't have said the GE Capital thing, but the point is, I don't know where they're going to go. But the point is, they've got, and I could go into some more detail about that, but they've got two clients called me going, well, who's going to do my lending types? I mean, it's starting to, it's going to start to affect things. People that are left there now, that are there now, that aren't in that, are going to have clients asking them questions about their resources and capabilities.
Well, the first firm I worked for, Miller and Chevalier, was a tax firm, and they had tax. They had international trade is based in D.C.
Right.
They had government contracts and a litigation group, but they had no significant corporate practice.
That's tough.
And it really, yeah.
Good morning and welcome to the monthly webcast presented by Pro Bono Partnership of Atlanta. We want to begin by thanking Georgia Legal Services for hosting this webinar on its website. My name is John Mills. I'm with Barnes & Thornburg's Atlanta office. And today we're going to do a continuation of the October webcast, which is about distressed nonprofits. This is part 2, and it's about whether to wind up the organization or go into bankruptcy. Last month we talked about how to determine whether the organization can be saved and going through all the financial and other issues associated with that. Before I start into the substance of this, I want to say that the mission of Pro Bono Partnership of Atlanta is to provide free legal assistance to community-based nonprofits that serve low-income or disadvantaged individuals. Pro Bono Partnership of Atlanta matches eligible organizations with volunteer lawyers from the leading corporations and law firms in Atlanta who can assist nonprofits with their business law matters. If you want to look at the specifics of what you need to do to qualify, it's on slide 3, and you must be a 501c3, be located in or serve the greater Atlanta area, serve low-income or disadvantaged individuals, and be unable to afford legal services. And there's some more information on slide 3 about that. Now, if you turn to slide 4, going to the subject for today, wind up or bankruptcy. Now, first thing to do is understand the options. We have 4 basic options. You have a wind up under state law, which I'll talk about. Assignment for the benefit of creditors, which is also a state law procedure. Chapter 7, a bankruptcy case. And a Chapter 11 bankruptcy case. And Chapter 11 has 2 prongs to it. You can go either liquidation or reorganization. I'll talk about that when we get there. Now go to slide 5. First thing to do, and we talked last month about looking at all the finances, is understand what funds are available to satisfy the claims of creditors, whether you're doing this in a wind-up or in a bankruptcy. And you're going to have 3 basic funds. These are broad categories. First is general unrestricted funds, quasi-endowment funds, and endowment funds. Now go to slide 6 and we'll talk about general funds. General funds are comprised of, and when I use funds in this presentation, the way I've used it in the PowerPoint presentation that you have, is I use fund as comprised of properties that are unrestricted. And when I say properties, I mean any kind of property that you could reduce to cash. So this would be if you have vehicles that you could sell and reduce to cash, that kind of thing, and turn into funds. So when I use funds, think of it broadly as properties. So looking at when you're going to say unrestricted, what do you have that you can either cash to pay creditors or property that could be sold and used to pay creditors? And that's how I mean it in the broadest sense. And you're going to have obviously 2 types of property: personal property and real property. Personal property being effectively everything except for land and buildings. And you will to look at that and find out what you have that's not tied to some restriction of some sort. And we'll talk about that. And then you have 2 types of restricted funds. If you go to slide 7, the first kind is called quasi-endowment funds. And the way to understand what quasi-endowment funds are to refer to the Uniform Prudent Management of Institutional Funds Act, and that's under Georgia law. And if you look at slide 7, it cites the statute. I won't get into that. The way it's defined, it's not defined, the term is not defined in the actual statute, because the statute itself, which I'll talk about in a minute, defines endowment funds. But you know what quasi-endowment funds are by what are not endowment funds. I know that sounds a little confusing, but if you go to the second bullet point on the slide, in the former version of the Act, and this substantively hasn't changed, quasi-endowment fund is defined as, and I'll just read it, a restriction on use that makes a fund an endowment fund arises only from the applicable gift instrument. If a governing board has the power to spend all of a fund, but in its discretion decides to invest the fund and spend only the yield or appreciation therefrom, the fund does not become an endowment fund under this definition, but it may be described as a quasi-endowment fund or a fund functioning as endowment. I prefer the term quasi-endowment fund. What that is general funds or property that the board of the organization voted at some point to restrict, saying we've got this money in from some source, and determine that, or equipment, or other thing, and we're only going to use it for a specific purpose, and we've done that. So there isn't a donative intent to restrict it. That's something that the organization did itself, and it's very important to understand, because if you put the restriction on, you can also remove the restriction and use that to pay creditors, should you choose to do so. And so that's an important thing to understand, because you might be thinking of funds as endowment funds, when in fact, if you drill into the history of, well, what is that fund, where did it come from, you may find that the organization itself some years prior caused the restriction to be placed and the donor did not. Now let's go to page 8, or slide 8. And that's what's an endowment fund. It's defined in the Act. And it's defined as an institutional fund or any part thereof that under the terms of a gift instrument is not wholly expendable by the institution on a current basis. So what we're talking about, that's a little bit of legalese there in the statute, is funds that you receive by some donative instrument, and that's broadly defined as a will. It can be anything, will, any kind of gift devised. It could just be under the Act, it could be just a letter sent with a check saying this is how I want these funds restricted. And Ms. Miller is going to ask me a question, yes, or tell me something, because she knows more about this than I do.
No, I have a question.
Yeah.
What if you were fundraising and you say this is for our endowment and it will be held, in our endowment funds? Does that automatically, if someone then writes you a check without putting anything on the check or a letter, does that restrict it?
No, that gets into quasi-endowment. Let's just go over to slide 9 and get actually it goes to slide. Let's jump to slide 10 real quick and we'll get into that. And that has to do with what is a gift instrument. A fund can only be an endowment, funds can only be endowment funds or property if there's a gift instrument that restricts it. And that's under the statute. And it says it, and that's defined in the Act as a record or records, including an institutional solicitation under which property is granted to, transferred to, or held by an institution as an institutional fund. I think that what you're talking about is, and you're saying fundraising could be the institutional solicitation, where you say, we'd like to, we're going to raise these funds and we're going to put this in the endowment. But I think you run into a question when there's no, when checks come in, unless someone has written a note with the check that says, I want this to go into the endowment fund as stated in the fundraising. I mean, there's no way to track in writing what has happened. And plus there's another issue with it that may come up with how do you so what you do with those funds at the end of the day in terms of trying to ease restrictions or other things. I'll talk about that in a moment. But I think it certainly raises a question, depending on how it's come in that way, as to whether you can segregate and say we know that let's say 75% of the fund or endowment fund is defined under the Act because we have gift instruments that tell us that. There's a possibility 25% may be endowment funds because there was a solicitation promised to be put into the endowment fund, but you have to check back if you have the records to see if there's really any way to determine that or that what hasn't happened is it's a quasi-endowment fund where the board has decided to put it in there. You know, under the assumption that based on monies that came in contemporaneously with the fundraising drive, that they were presumed to be put in the endowment account. I hope that answers the question. It's a little long-winded. These things are not necessarily easy to do. So you have your institutional fund. The bottom line with an endowment fund, let's go to slide 9. We jump to slide 10, but let's jump back to slide 9. Is you know, you may not spend endowment money in amounts or for purposes that are inconsistent with donor restrictions. That's the plain English way of stating it. The legalese way of looking at it in the Act is an institution may appropriate for expenditure or accumulate assets of an endowment fund as the institution determines shall be prudent for the uses, benefits, purposes, and duration for which the endowment fund is established. What happens to that is it restricts what can be done with it. And if you're trying to look at what to do in terms of satisfying the claims of creditors, you can look at that as a restriction. Another way to look at it, particularly as you look at what the donative intent of the gift that was that established the endowment, which is obviously to perform some charitable purpose, it can't be subject to the claims of creditors. Creditors can't attack it. Think of it like a spendthrift trust or some other instrument where it's not you have a corpus that's not liable to satisfy general debt. So the good news, there's good and bad news with it. The bad news is you can't use it to pay creditors, but the good news is creditors can't use it to pay themselves. So that fund can travel, or the property can travel, you know, as a group. So it's actually good news to the extent, you know, it's sad or bad if you're looking at liquidating a charity because it's going broke, but the good news is that fund can exist and go to perhaps another organization or go back to the donor, you know, to be transferred to another organization, or as we'll discuss, go to the Attorney General's office, state of Georgia, to be put with another organization. So it's a good and bad news. Now jump to slide 11. And this is something that you would get into about what do you do, can you remove restrictions on an endowment. Now generally, for the reasons I just alluded to, because of the purpose of it, you generally don't want to do that. That's not something you would be after. However, if you were in a situation where it's believed, and I'm going to talk very little about this because this gets into sort of complexity that goes beyond some kind of webinar. If you believe you're in a reorganization setting, and that if you, for example, I've seen this happen with hospitals, are a fairly common type of 501c3 that'll file a Chapter 11 reorganization case. And the idea is if some funds were paid to the lender, the bank, to sort of pay down the debt that's owed, so that the principal amount of the debt, let's say on the hospital facility, is such that it would become manageable to make the monthly debt service based on the income that's generated by the hospital. There's an argument, I've seen the arguments made, and I've made them, that if you could take some of the endowment fund and use it to pay the lender because it furthers the purposes of the endowment, which was to have a hospital and have a hospital warrant. And even though technically you're not supposed to pay the debt service on it, there are settings in which you would do that. So that's why I have listed on slide 11 why you want to look at maybe trying to modify the restrictions. Now, the easiest way, of course, is for a donor to waive the restriction in writing. And this gets into something, and I don't want to jump around and make this confusing, that was alluded to with Robin's question about when you ask when you've done an institutional solicitation, which would, to add to an endowment fund, which under the statute would constitute endowment funds. And if you have a situation where you can't really go back to the donors unless you've kept really good track about who gave $5, $10, and that's generally not going to happen. So that's not going to be available to you. But that's one of the reasons why it's important, I think, to, if you can, have donative intent reflected anytime you have endowment funds, so that you can at least have a whole corpus that is, or property that is, you can look to and know who to go back to if need be. You can apply to the Superior Court. You can try to get if the restrictions become impracticable or wasteful, and the modification of the restriction will further the purposes of the fund. You can also go to the Superior Court, but you have to let the Attorney General know. That Attorney General gets notice and can be heard on whether it's appropriate to modify the restriction. And the same thing is if a particular charity, if the purpose of restriction becomes unlawful or impracticable or impossible to achieve or wasteful, the Superior Court again upon application and with notice to the Attorney General and opportunity to be heard, can modify the restrictions. Understand both of these settings is got to be consistent with the donative purpose. So you can't have the restriction lifted and just start paying bills. It doesn't work that way. Generally what you're going to do is in the situation that I described with a hospital, a situation like that where you've got a corpus, you believe that the donative intent will be furthered by payment of a specific body of creditors or a specific creditor, like I gave the hospital example. So that's what you would go. And the only reason why I think you would end up there is if the donor refused to waive the restriction or you can't find a donor. Donor's no longer around. So that would typically be happy when you get a donation by will, by the person dies, you find it that way. Now, let's go to slide 12. Once you decide sort of what the buckets of funds are you have and what you can do, you need to take board action. That's the first thing. And when I say board action, you got to vote under General Georgia corporate law. You got to authorize this. We're going to wind up. We're going to file a bankruptcy case. And typically what you want to do is designate a responsible officer. I say not, normally you might think officer or officers, but no, you want to designate one person, because what's going to happen is there's going to be a lot of stuff to sign, and you don't want to be scrambling around trying to find 2 or 3 people to sign stuff. You want to make it easy. Plus, in the event you're going to wind the thing down, there's going to be no reorg, which is the likely scenario. You're not going to have staff around, you're not going to have people, it's just going to be the one person probably operating out of their home, doing their other office in addition to their day job, so to speak. So you want to make this so it's easy for them to do. Now go to slide 13. And this is wind-up. And when I call it a wind-up, this is a wind-up that's not a bankruptcy setting. And what I mean by that is it's under state law, it's provided for, and it provides for the payment of all creditors. You may determine that the organization can't survive, can't keep going, but nevertheless you can satisfy the claims of all creditors, take endowment funds and transfer them to other organizations into orderly, what I call an orderly wind-up. So you make a plan for that, you make a payment, you provide it to the Attorney General for approval. And if the Attorney General approves it or doesn't get back to you within 30 days, implement your plan. Go for it. If you have any property left over, you distribute it to other 501c3s, or you give it pay it over to the Attorney General, transfer it to the Attorney General, who then will, that office will distribute it to other 501c3s. So that's quick and dirty how that happens. And now we have a question.
One of you is asking who should be the responsible officer. Is it generally the board chair?
It can be anyone, to be honest with you. What I would do is the answer is no, to be polite, unless the board chair is actively involved in the organization. Or the responsible officer ought to be someone who's very knowledgeable about paperwork, where things are, where files are, books and records, ledgers, that sort of thing. But generally a chair I don't think of as being that hands-on. I know in some organizations if they're small enough, the chair, everybody's doing everything, so it may not matter. But if you're looking at a normal hierarchical system, you don't have that. For example, the best way is if you translate that over to a for-profit corporation. Typically when you do a Chapter 11, whether it's a liquidation or a reorg or any kind of bankruptcy case, the board will designate a responsible officer. It's not a board member, it's not the chair, it's generally like a CFO, chief financial officer type, or a vice president in charge of X, usually operations, because the folks on the board are not going to be in the best position to aid lawyers, accountants, or whoever else, or assist a bankruptcy trustee with getting information or creditors. So, the answer is no.
Thank you.
Go to slide 14. We have another option outside of bankruptcy, and this is liquidation, is assignment for the benefit of creditors. This is rarely used. It's used for for-profit companies more and more and more, and the reason for that is it is cheaper than bankruptcy in terms of cost. Very cheap in comparison. With bankruptcy, what you have is you've got a process that goes through the court. You've got to have lawyers that go down to court. You've got certain paperwork that's got to be filled out, schedules, what they call the schedules of assets and liabilities. You've also got something called a statement of financial affairs, which is a fairly extensive form document requiring all sorts of information. You also have other minor schedules that I won't get into that you fill out. You effectively file a huge stack of paper with the bankruptcy courts and then you'll have, in a Chapter 7 case, you'll have the follow-up by a Chapter 7 trustee who will generally ask for lots of information, showing the tax returns for the last few years, this, that. They keep coming to you for information over and over and over again. This is where the hands-on responsible officer comes in. In a Chapter 11, whether it's a liquidation or reorganization, you file that same stack of paper that I just talked about, the schedules of assets, liabilities, statement of financial affairs, other schedules. In addition to that, you have things called monthly operating reports that have to be put in, even in a liquidation. You've got to have certain things on file with what's known as the Office of the United States Trustee. The Office of the United States Trustee is a division of the United States Department of Justice, and it's charged with monitoring bankruptcy cases. And in Chapter 11, think of it as a fishbowl, whether it's totally transparent, or that's what it's intended to be, whether it's a reorganization or a liquidation. So what happens in these cases is the U.S. Trustee's office, in order for you to be to run a Chapter 11, will require all sorts of information be put, sent to that. It requires things like, for example, even if an organization is liquidating, it will still be in charge of its checkbook. It will still have various things, and so you have to change your bank accounts into what are known as debtor possession accounts and various other things. And so there's all sorts of very tough, very burdensome process in terms of administration. Less so in Chapter 7, and we'll talk about that. I'll talk about that more detail when I get there. Because of the differences in Chapter 7, a trustee is automatically appointed and takes responsibility, whereas in Chapter 11, where there's liquidation or reorganization, the debtor is left in possession. In order to have that privilege, there's a lot of paperwork they want to know about that. So what an assignment for the benefit of creditors is basically an instrument which takes all the assets, or at least the ones that are available for distribution to creditors, right? And it's an instrument, and it's assigned to a liquidating fiduciary who then takes that and it reduces it to cash and distributes it to creditors. If there's anything left over, it'll get distributed given to the Attorney General for distribution to other nonprofits, or it'll go to or distributed to other nonprofits. I'd suggest to you that liquidating fiduciary and an assignment for the benefit of creditors will just give it to the Attorney General. That's it won't be anything to be done. I think there isn't the same amount of paperwork involved. It's a sort of a sign and walk away type of situation. Nevertheless, we'll need to have a responsible officer because that liquidated fiduciary is going to have questions, and so it's becoming more and more on the for-profit side used where folks have decided to do a liquidation because it's a way of getting, because the administrative costs are so much less, it's a way of getting more money to creditors. Because what happens in the assignment for the benefit of creditors or in a bankruptcy setting with a trustee is the trustee or the liquidating fiduciary is paid out of the proceeds of liquidation. So if the administrative costs can be held down, then that's what you want to get. It's more money to creditors. And in setting it's just, look at it as, first of all, it's the right thing to do. I would suggest to you to try to do that. Second of all, you see it, the reason why it's used more in the for-profit setting, to be honest with you, is a lot of folks have personal guarantees and they want to minimize risk of collection on that by maximizing the amount of money that goes to credit. Endowment assets will go either to the back to the donor or to other 501c3s or go to the Attorney General for distribution. The next option, and this is on page 15, is Chapter 7 bankruptcy, and I call this straight liquidation. And this is similar to the assignment for the benefit of creditors. Basically, everything's liquidated and thrown into a pot and distributed to creditors, according to certain followers. When I say everything, it's broadly defined in the bankruptcy code as all legal and equitable interest of the debtor in property, and it becomes an estate, and it's a legal thing that happens. In an assignment for the benefit of the creditors, the estate is formed by the assignment document under state law. In bankruptcy, it's automatic. Once the case is filed under the bankruptcy code, automatically an estate is created, and it's everything. And automatically also under Chapter 7, a trustee is appointed. And the technical process is there's a panel that we have in the Northern District of Georgia. There are similar panels anywhere in any state in the country, where once a case is filed, a computer automatically assigns a trustee to a case. So it's a very automatic process. The liquidation is going to be a fire sale, and that's because the trustees don't hold property for later on. They don't, like, for example, let's say a charity had an income producing property like a rental home or a rental or apartment. Trustees don't hold that and say, okay, we'll wait for the economy to get better and we'll wait for the real estate market to turn. That's not what they do. They just sell now, and which can result in many people lower value of things. I can tell you now, if you file a case today, it would result in lower value. I'm not advising against filing cases if they need to be filed, but that's just something to recognize. It's a fire sale. With an assignment for the benefit of creditors, I don't mean to jump back and forth, but I think the contrast should be made. There's a little more flexibility you're going to have with the liquidated fiduciary to try to maximize return a little more on the liquidation side. Mainly because that liquidating fiduciary that's going to be a special deal. A liquidated fiduciary which can be an individual or like an accounting firm. That's why I sort of use a legalese term for it, because it could be me, it could be my law firm, it could be an accounting firm. A liquidating fiduciary is going to be doing that on a sort of special basis, so there'd be more of an inclination to maybe hold property and see if it appreciates in value to maximize return. A Chapter 7 trustee, as I said, is automatically assigned. In the Northern District of Georgia, we're the second or third largest consumer filing district in the nation. The same Chapter 7 trustee that is appointed, would get appointed in the Chapter 7 case of a 501c3 or a for-profit company, is also the same trustee that will be appointed in consumer cases. So these folks have thousands of cases, each trustee will inundate. So there is no inclination. They just want to hit it and move on, hit it and move on. So that's to understand the dynamic of the trustee. And the same thing will happen in Chapter 7. The excess funds, if somehow all creditors got paid and all costs of the trustee were satisfied, then any funds left over would go to the Attorney General for distribution to 501c3. One thing to understand about Chapter 7 is that the trustee, by statute, is charged with investigating the financial affairs of the debtor. So a trustee will tend to look at the books and records of the debtor and see just what money's gone in and out. And so in the event there are any transactions with respect to insiders or affiliates, then those will be looked at. And you have to understand, sometimes I know, and this happens in for-profit entities, and I can see it happening with non-profit entities as well, where folks trying to keep the thing alive will loan money into it or just throw money at it, expecting to be paid back on a loan basis, but that would be poorly documented, if at all. And so the money gets, and then when it's decided we're going to liquidate it, then, well, I want to be paid back my loan money. And been problems arise with that. And so I just caution you about that, that you're gonna have a fiduciary involved, and it's gonna be looked at. So to the extent you have to, in deciding to go that route, step back and look at that and see whether any sort of things need to be documented and that kind of thing. Even if there's documentation of all that, one of the things under bankruptcy, under Chapter 7, is what's known as preferences. It's called avoidance action. And you probably heard the most common term is called clawback, and that is that the creditors who are paid within 90 days of the filing of a bankruptcy case, under certain conditions, can have the money paid to them returned. So a lawsuit is filed within the bankruptcy case. It's called an adversary proceeding, and the money paid is returned. There are certain defenses, various other things that I won't get into. It's just enough to know that any unsecured creditor that's paid within 90 days of the filing of the case is at risk that money may have to come back. Any insiders, which would be officers and directors of the debtor, who are paid within 1 year, are subject to this same clawback. So it's just something to think about and understand that risk is out there. Now we go to 16, Chapter 11, orderly liquidation. And this is, again, you file a case and it's all legal and equitable interests of the debtor and property are put into an estate. But no trustee is appointed. And a trustee is only appointed where there are bad acts or gross mismanagement. Generally, creditors have to move for that and seek that. And then, so a situation where you wouldn't be allowed to be a debtor in possession, the entity wouldn't be allowed to be where the creditors are pretty unhappy and think that there's going to happen. They would have to, but the creditor or creditors would have to convince a bankruptcy judge that there's credible evidence that there's been gross mismanagement of the organization. So be aware of that. I doubt that's there, but it's something to understand. You control the liquidation. So the good news here is it's a way to manage liquidation in a way to maximize return to creditors and possibly have some left over to go to other 501c3s. And I'll go back to the example that I gave, like if there's an apartment building or something and it's got rental income that pays taxes and various other things, but it can't make full debt service, and there's a problem with it. It could be held, presumably under a plan of liquidation for some period of time to see if that can be upturned and value can be maximized. So that's the advantage of doing something like this. And there's argument to be made, depending on the type of business and assets that a company has, 501c3 or for profit, that the management or board of the entity is better, in a better position because of some unique situation in the industry to manage the liquidation because they know the business. And so it's a very, you have to think about that process. The problem with it is it's very expensive because what it is you're in a situation where it needs to be transparent because you're effectively holding off creditors and letting old management run the thing, whether it's liquidation or reorg. And so there's a lot of reporting requirements, as I mentioned before, with these monthly operating reports and everything. It generally requires employment of an accountant that is paid from, by the entity, paid from liquidation proceeds, lawyers as well. And although you can find lawyers on a pro bono basis, probably accountants are much more difficult. And I don't mean to disparage any accountants that may be watching, but it's a little different. And so you do have these administrative costs, and it's something to understand. And you have to, when I talked last month about this and trying to get a handle on whether the organization can be saved, there was an issue about valuation of assets. If you figured out what things are worth, maybe you can sit down with a sheet and this makes sense, to do the order of liquidation because of what is the good faith belief in the value of the asset is going to be, and an understanding of we can't just file 7 and just have it just done overnight because we won't realize those asset values. I would urge you, if you do that, be realistic about it. One of the hardest things to do is to sit down and sort of stare in the mirror, so to speak. It's hard for me to do to look at myself and go, gosh, you're such a, whatever. And to realize sort of where things can be. And so when you look at projections on asset values, like anything else, it's just a guess. Let's just be honest. It's a guess, and it's just a question of how educated that guess is and how realistic it is. And so when you look at those asset values or what you think you can get as weighed against the high administrative costs of an 11 and the time it takes too, one of the things that's going to come about is I could foresee a situation, particularly if there's real property involved, where whether it's a non-profit or for-profit entity shows up down the bankruptcy court saying, well, if we can just do a plan of liquidation, we'll just hold this for 5 years, we'll be able to pay everybody off because the market's going to come up and here's the projections and the economist and things like that. That's going to be a little too much for a bankruptcy judge because that becomes a bit speculative. So I would just a rule of thumb, if you're going to go out over a year, you're going to be looked at very skeptically by everyone in the courtroom. So just sort of use that. I'm not saying that's the way it's hard and fast rule, but just I've been doing this for a while, and people start rolling their eyes the longer you get out in terms of affecting a liquidation. Plus, there's a risk that other things can happen. You can have fires. There's lots of other things. Speaking of which, one of the administrative costs, or one of the things that you're going to have to understand in an operating 11 where there's a wind down liquidation. I mean, you got to pay insurance. You got to pay all the things that we're paying. So understand that. So because that's another thing that's going to happen, and you may in order to. And it may be that the coverage, certain insurance coverages have to be raised in order to satisfy creditors that there won't be a risk over time that something's going to go wrong. You may be required to buy coverages not normally taken, in other words, an added cost in order to buy that time. So be cognizant of that. Finally, we go to slide 17, and that is reorganization. Again, I should put this at the back, and you haven't talked about it that much because it's going to be something that generally isn't in the cards. It's usually in the cards for things like hospitals or other operating entities that are sort of generating cash all the time on a daily basis. In other words, it could be a for-profit business, but it just happens to be a charity. That's going to be the more common thing that you're going to have that's going to be real, because you're going to have situations where, well, if we can just sort of rewrite the lender's note a little bit, and we can make it happen, because you're not dependent on, solely dependent on grants and donations and various other things. There's people coming in, you're taking insurance, you're getting paid, you're taking Medicare, you get paid. There's various ways to do that, so there's income being produced. And anytime you have a cash flow like that, then there's a chance of reorganization. And generally, when we've got grants and donations, that's not the kind of cash flow that you're looking at normally that sort of is the makings of a reorganization, because you can't count on it. Granted, you can't count on income flow, but at least you can go back and understand that, you can at least, for example, I'll just stay with the hospital. You can at least know what the population of your area is, what the population is that the hospital serves, and you can sort of get some demographic and other metrics fairly accurately determines of what you're going to be looking at in terms of your cash flow, which you really can't do with donations. That's just a tough thing to do. And to give you an idea of dynamics, I'm going to talk about cars and trucks for just a second to give you an idea why you can't really tell who gets into donation. Is, for example, many of you have heard most people want to buy a pre-owned vehicle now because they don't want to buy a new vehicle. Well, guess what? You can't buy a 2 or 3 year old pre-owned vehicle. Those will almost cost as much as new cars because there's such a demand, because everybody wants to do that. So there's unintended consequences with all this sort of thing. That can happen with donation. The slightest little thing out there in the economy can cause a weird unintended effect. All of a sudden you get donations tailing down. For example, I would suggest to you, this is not political or anything, but I know that corporations are holding money now because they're uncertain as to what's going to happen with taxes, going into next year. So there's a real, and if taxes do go up, and it's obvious there'll be less money to go to charity, so that can affect donations. But they've been bandied about in terms of tax policy limiting for individuals the deduction for charitable donations, things like that. So anything can affect you, so it's harder to predict. It's not very much. So it's usually a cash flowing business that's going to be real. You control it. You're the debtor in possession. This is very expensive, and it's going to require paid lawyers, because a reorg pro bono that will be, it's huge. And the reason for that is, and the same thing happens in a liquidation. You got to file a plan of liquidation. You've got to do a disclosure statement that's incident to that. But a plan of liquidation is a very small document. We're selling everything. A plan of reorganization is a whole nother animal, and there has to be a disclosure statement, which basically is measured by would a hypothetical investor accept this type thing. And so it's a huge document, and it requires a whole bunch of statutory provisions that have to be satisfied in terms of what its contents are. Again, the same document's done in a plan of liquidation, but I'm not going to get. It's not as important because you're liquidating. So you're supposed to say over and over again, liquidating. Reorganization is very different. So it's extremely time consuming for lawyers and accountants, and you're going to have to be paid because of what is over and above what happens. So again, it's going to be more appropriate for a large scale operation, more appropriate for something like a hospital or some other country. Now go to slide 8, and here's the one that everybody needs to understand. And it harkens back to, and this is not a scare tactic. You just don't know. So I talked last month about taxes, and in some sort of situations there could be personal liability for officers and directors for not paying their taxes, certain types of taxes, payroll tax, for example. And so the filing of a bankruptcy case by the organization won't affect that. So if there's a taxing authority, if there's some situation in which there's personal liability that attaches, not going to get away. If those taxes can't be paid out of the liquidation, then there's a risk that the state and federal taxing authorities will come to the responsible officers and directors, and consistent with that liability, try to collect it. So understand that this is not a panacea. This doesn't cure all your ills. If there's other personal liability, and by that I mean, I'm generally going back to the loan issue and things like that, where you might be liable for clawbacks on loan repayments or things like that. That's there. Just recognize it's there. But bankruptcy doesn't. If you were on the hook for something, and I don't under state or federal law, bankruptcy won't alter it. So that's just something to understand, that there's no way out in that sense. And that's it, unless folks have questions.
Are there any questions?
All right.